children.
Yes, Mr. Hale.
My Lords, can I now move directly to dealing with ground 2 of the appeal, dealing directly with communicated and uncommunicated intentions? The starting point, my Lords, is the words of Article 3 of the 1980 Child Abduction Convention. One thing that we agree wholeheartedly with the appellants is that that article needs no gloss. It must have no gloss for its application to be applied appropriately across the board. The act of wrongful retention is defined therein, and it is ultimately a matter of fact to determine on a case-by-case basis whether the acts accompanied by intention amount to a wrongful retention, whether a wrongful retention has occurred. In our respectful submission in this case, we submit that Lady Justice Sharp and Lady Justice Thirlwall were entirely correct in their reasonings given at paragraph 176 in the judgment, at MS 202 to 203.
Reasoning, did you say?
I did, my Lord.
Very well.
And the reason I say that, my Lord, is because here Lady Justice Thirlwall and Sharp were relying in agreement with Lady Justice Black's analysis in paragraph 133. And in that paragraph, Lady Justice Black's view, and I'm looking at the second half of paragraph 176, where they say, we agree with Lady Justice Black's view, expressed at paragraph 133 of her judgment, that there may be cases at either end of the spectrum. Ultimately, however, whether anticipatory retention has occurred is a question of fact to be resolved by reference to the evidence of the circumstances. And we regard this as a practical question, not a theoretical one to be judged by reference to the facts of the individual case. Well, we rely wholly upon that.
Can I just, what puzzles me about this is you said that you don't want to gloss Article 3, but this whole idea of anticipatory breach, or whatever you call it, is a gloss. And the question under Article 3 is whether there's been a breach of the rights of custody attributed to a person, in this case, your client. I mean, why don't we just ask that question?
Well, we do, of course, as part of the analysis.
So the question is, what breach of your client's rights of custody occurred either in November or any of the other dates we're talking about?
My Lord, yes, but we have to fix within that a wrongful retention.
Well, no, that's the definition of a wrongful retention.
Well, it is.
To find out whether there's been a... First of all, ask, has there been a retention? Secondly, is it wrongful? To answer that, you have to ask whether there's been a breach of your client's rights of custody. That's surely the only question.
My Lord, it is, and it amounts to the same, in effect, on the same analysis on the evidence. It is the same question. The reason, my Lord, and I accept entirely, the reason that at first blush the concept of anticipatory retention, or as it's described, anticipatory breach, may look like a gloss is because it's a term that's been used within convention cases around the world. That, as I hope that we've stressed yesterday, we much prefer Lord Hughes's, if it indeed is an express view, that wrongful retention is the correct and only phrase, and that being the phrase within Article 3. The question is, what's the evidence, as my Lord said, of the breach of custody rights of my client in this particular case? And we say, in this case, factually, it was plain, and there needs to be no gloss. But
well, surely your answer to my Lord is that a simple formulation of the question posed by Article 3 is, when the mother determined to keep the children in the United Kingdom in contravention of the agreement that she had reached with her husband, that was the occasion of a breach of the father's custody rights. And that doesn't require any gloss. That's a simple formulation.
It is. It is, my lord. And of course, the question has arisen because one looks through trawls through the cases that Lady Justice Black very ably did in the schedule that she produced in the Court of Appeal in the court below. The facts are also very different, causing different views to be taken in different Hague Community countries. But, my lord, that is, with respect, in a sentence, our position, that it is a simple question of fact to be determined within the period of agreement if there is evidence showing breach of custody rights, wrongful retention, that is the act upon which the applicant can act. And it would be wrong, and we've said absurd, because that's the words used by Lady Justice Sharp and Thirlwall, to suggest that there be some rule or gloss that means that it cannot be relied upon until the end of the term.
It depends what you mean by a breach. I mean, there's a huge spectrum of things that might be regarded as a breach, but if we looked at the analogy of domestic law, probably wouldn't be regarded as a breach. Obviously, there is doing something which is directly contrary to the rights of the other parent. That would be not returning the children when agreed. That's easy, and that's obvious. Doing something that puts it out of your power to do what you will have to do at the end of the term may or may not be. That's the next one down.
Yes.
Doing something that indicates an intention not to do that is next one down. Not doing anything very much, but forming an intention is way down at the bottom. Can it be the case that simply forming an intention but not doing anything about it, or not doing anything unequivocal about it, and not communicating it, is actually a breach of the other parent's rights? Because if so, I bet most parents in this country will be breaching other parents' rights all the time.
Well, my lady,
Every time a parent returns a child, or decides to return a child late from a contact visit, it's clearly a breach of the other parent's rights.
my lady,
Or is it?
the provisions
I mean, that's the question I'm getting at.
The provisions of Article 3 aren't in play with parents who simply have a personal change of mind. They are
right. So you are disavowing any personal change of mind. There has to be overt acts.
No, my lady, I'm not. What I'm saying is that in practical terms, it won't apply, because the mother who forms an intention within the period, in her own mind, on a Monday after a difficult conversation on a Sunday, that I am not returning the children at the end of this term, who changes her mind on the Thursday after a less difficult conversation. It's a practical question. One could not for a moment suggest that if it transpired in evidence that she said, well, on the Monday I agree I didn't want to take them back, and I said perhaps to my mother I wasn't taking them home, but on the Thursday I changed my mind, that wouldn't, we say, amount on the evidence, on the facts, to a breach of Article.
But what if she doesn't change her mind? I completely understand that simply taking into account a subjective intention formed at a particular time to fix a date would be most dangerous, because people can always change their minds.
Yes.
And coming up to the date when you're supposed to be doing something is a fine concentration on your obligations. So that would possibly not be right. But what if she forms the intention and then carries it through? Is the date when she carries it through, i.e. doesn't return the children, or is it the date when she forms the intention?
My lady, it will be a question for the judge in the facts of that case. The answer would be, we would say, without anything more, the date that she formed the intention.
Well, there we are, you see.
It would have to be. So in our
But it's one date and one date only. That's the problem you've got with this convention. If it were a floating date, it would be a bit different. But
Milady, if there were to be the alternative, I'm taking in a sense my submissions out of turn, but
I'm
if there
sorry.
was,
Well,
no,
don't
of
let
course.
me.
If there was to be an alternate proposition to that, we say it would be a charter for deceitful parents, for the parent who simply withholds the information and acts in a way as not to disclose the real intention in order to benefit from the position at the end rather than the position at the time that she held the intention.
Well,
Retention, after you, please.
sorry.
Retention is doing something, isn't it? There's got to be, forgive me, an actus reus, hasn't there?
There has.
And so a simple thing, unusual though it may be, we've got to wrestle with these hypotheses. The very unusual situation of the woman making a decision but taking no act in furtherance of it might well not disclose the necessary actus reus. Of course, that's not this case, but we've got to look at it more widely. If, and the argument is this has never been properly considered so far, if the mother here did in November have the intention not, or had made the decision not to return the children in June 2016, she did take an act in furtherance of it.
She did.
She made application.
She did.
So it's perfectly clear that on that hypothesis, we're not here dealing with a simple, unusual, internal decision not furthered by an act.
No. And my lord, it's perhaps an entirely unrealistic case because always, perhaps it's too overstating, almost always, the intention will be accompanied by an act.
You might test it if it's necessary, if you postulate this case, which is perhaps just possible. Come the hearing, the travelling parent asserts 12 months has passed since the retention became unlawful and the child is settled. And I can say that because I can tell you that a month after I arrived, I made the absolutely clear decision in my mind that I was under no circumstances going to take them back. I didn't do anything about it in the sense of writing to the Home Office or making irrevocable applications to schools or anything of that kind, but that's what I decided to do, and I'm telling you that, and therefore I say the 12 months runs from then. Now, how does one, I mean, is that a realistic scenario or not? Probably not.
Well,
it won't happen very often.
Well,
but supposing it did.
my lord, it is potentially the consequence, we say, of the gloss proposition.
Well, never mind whether it's a gloss or not, that's advocate's language. What do we do about the kind of situation that I've had in mind?
The question that we're looking at is whether something is a breach of the other parent's rights of custody. That's the question we're looking at, which is why I put the different levels of possibility to you. Yep. And my lord is again putting to you, what if somebody forms an intention, which is a perfectly clear intention, but doesn't actually do anything unequivocally in support of that intention until the end of the period when they fail to return.
Indeed, positively conceals it.
Yep.
Well, it may well be that in those circumstances the judge determines that intention alone at that time did not amount to a breach of custody rights.
That's not what you said to me when I asked you the same question.
Well, my lady, if I
wonder
didn't...
whether you want to make that concession.
I get back to my original submission, my lady, that it is, whilst we postulate these different potentials, ultimately it will be a determination for the judge.
Well, it will, but you've got to have a breach of the rights
Yes.
of the rights of custody of the left behind parent, haven't
Yes.
you? What is it? It can only be, I think, but please tell me if I'm oversimplistic. It can only be continuing to retain the children, not on the agreed basis but repudiating the agreed basis
Yes. If,
and saying, I don't care what his rights are, I'm going to keep him here anyway.
So if we move forward on that postulation, my lord, and the only evidence is that the mother's concrete intention after a month was to take advantage of settlement because she knew her rights so sufficiently and knew this case not to communicate her intention, then the judge would have if the judge found that in fact that intention amounted to a breach of rights of custody, then the judge would have to then determine settlement. And what in those circumstances, what practically would a judge do? Well, we're back to those cases about turpitude, aren't we? And the position of deceit and an active parent who seeks to breach the rights of the other parent in the assessment, firstly, of settlement. And if she brought a case of habitual residence, my lord, that would factor in to that application too.
All of that.
So if one postulates the difficult case, in my respectful submission, the well-armed, able judge will deal with the difficult case. If the only evidence is the intention of the mother on that day, forcing the judge to find that that was the date of retention and in breach of custody rights, well, my lord, then so be it on that evidence. The judge will then have to deal with the difficulties of that particular case.
Okay, so basically you're saying it's a question of fact and it's all down to the judge. We are, in fact, talking principles of law here. We're talking concepts of law, and we're trying to explore with you what those concepts of law are. We can't have a situation where, in one case, an uncommunicated intention is enough, and in another case, it's not. We can't have that situation. That's just not right in the context of this particular convention, or indeed in most other things. So this is why we're pressing you on this, because it's very, very important, and not without its difficulties.
No.
For a start, concrete actions may be evidence of intention, but unless they're unequivocal actions, they're not necessarily evidence of a concluded intention, which is bound to be put into effect.
No, and we discussed yesterday the application to senior school as an example of that. But one could easily factor any other than factual matrix to see that it would be unequivocal. The father's not told, the deposit's paid, the child is enrolled, the headmaster's told the child starting in September, which is beyond the date of agreement. Those sorts of facts would be on one side of the spectrum. The tentative, let's look at the senior school, let's go to the open day and let's think about it, would be on the other side. But again, I'm going back to the facts. I understand the difficulty, my lady, of course I do, standing here, in the submission. Of course I do, that there must be a consistent approach to this. But, my lady, I have to say it's a matter for the judge. I have to, because in terms of intention, if that's the only evidence, then the judge will have to pick the date of retention.
Yes.
It's his only intention that is the only evidence, which will almost, it seems to be, never be the case. But if it is only intention, then the judge will have to deal with that case, with that position.
He's tried to say that there may be a change in the status of the breach of the father's custody rights, in that if there is a change of mind on the part of the mother, then the custody rights can be respected. So a decision taken initially as to the mother is going to return the children to Australia could constitute a breach of their father's custody rights. And then if she repents of that decision, there can be a restoration of his custody rights. So one, I think, needs to recognise that fact as underlying. But turning to the point that was made to you about a determination not communicated to the father to allow the period to run for settlement, I mean, surely your submission must be that constitutes a breach of the father's custody rights, even though it's not communicated, because it's a determination to allow the 12 months to elapse from the date that the decision was conceived, so that she can take advantage of the settlement provision.
It must be my submission, my lord, that it is the breach of custody rights at that moment, at that stage. It is also a breach of the agreement, but it's a breach of custody rights because the other parent determines to act in a way contrary to the rights of custody of the, as we've described, the left behind parent.
Yeah.
It is our respectful submission on that basis that the communication to the other parent is not necessary and not necessary to find what's been described as an anticipatory retention. What we say would be a finding of wrongful retention. The vast majority of cases, there will be direct or indirect communication of the intention, either by others or by acts inconsistent with the agreement and inconsistent then with the custody rights of the left behind parent. The difficulty, of course, arises in those cases where, as my learned Lord Hughes has already taken me to, the admission in the witness box case, where there is no other evidence that surrounds the admission about the date of retention. Well, those are very, very difficult cases, but we say are very, very likely to be very rare, where there is nothing that supports. I accept, of course, the position put to me that those are the cases that the court has to deal with. But ultimately, as we said, and I hope I'm forgiven for repeating, as Lady Justice Thirlwall and Sharp said in the court below, ultimately it will be a question of fact to be resolved by reference to the evidence. There are, of course, in the submissions, in our written case, the examples of the other cases of uncommunicated acts of retention in AZ, which is at MS 121 in the written case, and at 1118 in the authorities one. So I don't intend to take my lords, my lady to them. But that was a case, of course, of an aunt making an application herself within the period of the agreed term, and that application of itself was found to be the act of wrongful retention, or even though it was ex parte, and was at the point not referred to the father until, of course, later, well, no doubt until it was served. There is, of course, the decision of Mr. Justice Wall, as he then was, in Ries, and we've already dealt, my lady, with the seminal phrase, in a sense, from that, the benefits and the burdens. And that goes, we say, directly to the issue of rights of custody. The burden is not only, we say, to return the child at the end of the term. The burden is also to respect the rights of custody of the father. And in breaching those rights of custody and in breaching the agreement, it is the evidence of the act of wrongful retention. Can I take my lords and my lady then to page 131 in our written case? Lady, this of course is where we deal with the questions that my lady posed in terms of the difficulties involved with uncommunicated acts. We say, of course, that Lady, as I started my submissions, in paragraph 133 of her judgment, Lady Justice Black starts with the proposition that it is, in fact, a question of fact. That is the aspect that Lady Justice Sharp and Lady Justice Thirlwall agreed with. And then Lady Justice Black, in a postscript, dealt with what she regarded as as she described, as a policy decision. So in our submissions, Lady Justice Black adhered to her view that the private and uncommunicated resolution not to return is insufficient. That's at 173 in the judgment. But then expanded her view to include matters that had neither been communicated to the other parent nor reached his attention by other means. And in conclusion, she, of course, took the view that the setting of the boundaries of anticipatory retention is a policy decision. Well, that is the point of which departure happened with Lady Justice Sharp and Thirlwall, and as we respectfully agree with the majority of the court below, that the concept of it being policy decision would produce, we say, some potentially absurd results. In terms of ground one, it would be the sitting on the hands position. And in terms of ground two, it would potentially create a situation where, notwithstanding, we say, a case where a judge at trial hears evidence from the retaining parent as to a date, that if in fact that evidence had not been communicated to the left behind parent, that there would be some rule that would mean that the judge would have to put that out of his or her mind, or disregard or not apply sufficient weight to that evidence. Well, that, we say, would be absurd. That would potentially be the consequence of the policy decision that's being promoted, notwithstanding, of course, the difficulties that we accept. Moving on to the, if I may, the consequences, if there isn't such a gloss or policy decision, Lady Justice Black went on to say that such an approach would avoid far-reaching trawls through all conceivable aspects of lives and correspondence of the parents and children, both in pre-trial and evidence in court. And that's paragraph 175 of the judgment at page 202 in the bundle. Well, my lords, we don't accept, with the greatest respect, we don't accept that. And in support of that submission, we would say the following. After 5 seminal cases concerning habitual residence in this court, the law of habitual residence has been brought in to line, as we discussed yesterday, with the European position. The courts of England and Wales have had to adjust to that, and that has led to trials with evidence in these cases concerning habitual residence. And it's right to say that that has increased to some extent, the forensic inquiry in these cases. But as my Lord Wilson said yesterday, if the consequence of that is to the better welfare of children, then that's to be, we say, applauded and not derided. In this type of situation, if this led, and we say it might, to some oral evidence on the point, then it may increase to some extent the evidence in these cases. But we don't agree that it would mean a far-reaching trawl through all conceivable aspects of the lives and correspondence of parents and children. We certainly don't, with the greatest respect, agree with my learned friend, Mr. Setwright, who spoke yesterday in terms of significantly dire consequences, an open season for potential chaos if you allow uncommunicated intention. Well, with the greatest respect, we don't agree with that at all, and that dire consequence has not happened post the habitual residence change. and more importantly, my lords, my lady, the guidance that Lady Justice Black gave in this case in the court below in terms of the management of Hague abduction cases generally I'm very pleased to be able to say, and confirmed by my juniors at the coalface in these cases, been referred to and applied now regularly within these Hague abduction cases. And so there is robust management. And my lord, it's at 202, page 202. No, sorry, forgive me. Thank you. 199, forgive me. 199.
I'm sorry, Mr. Hale, could I just revert to something that I think something that was started by my Lord Carnworth, and I've been bothering about it ever since. We have assumed that return in Article 12, and wherever else it's used, but Article 12 is the obligation to return, means return to the country of habitual residence. And as a result of that assumption, if the child's habitual residence has changed over a period of absence from that country, then the child can't be returned. And of course, it's true, the child can't be returned to the country of current habitual residence because the child's already there.
Yes.
It's clear that Article 3 is referring to rights of custody attributed to a person under the law of the state in which the child was habitually resident immediately before the removal or retention. Now, for the purpose of applying that provision in a case such as this, it doesn't matter where the child is habitually resident because the father will have rights of custody under either Australian law or under English law, subject to the Western Australia problem, which may or may not have been fixed since we had all those cases about it. But
Indeed.
As a general proposition, the father will have had rights of custody, whether it's under whichever law.
Yes.
So is it in fact a given that return, which is not, as far as I know, defined, and somebody will tell me if it is it a given that return has to be to the country where the child is habitually resident now, in which case there can be no return if the child's habitual residence has changed? Or is it that return means, in effect, return to the place from which the child was removed or has been kept back wrongfully?
Well, my lady,
It would make an awful lot of sense if the proposition I've just put to you were the case. But I appreciate that it's against all received wisdom, but that was before we actually had to confront this problem as a result of the possibility of there being a change in habitual residence during the currency of a period of agreed absence.
I think, and I know that Mr. Setwright perhaps would be better positioned to answer this question, but because I know...
Well, he'd be horrified if the answer was...
Well, I know that he was in... I know that... I believe, forgive me, he'll tell me if I'm wrong, that he was in the case where that very position was postulated. I think a case called Re-O, where there was an argument about whether the child could be returned to a third state.
Yes.
Rather than...
But I'm talking about returning the child to the place from which the child has been either wrongfully removed or wrongfully retained.
Well, certainly, my lady, the received jurisprudence wisdom, if I can put it in that term, has always been back to the state from which the child came.
Oh, yes, but the question is,
Whether that's habitual
Exactly.
the question is, does that also have to be the state where the child is habitually resident, or was at the time of the wrongful act?
Yes, whatever that might be.
Well, my lady, the interpretation of these treaties, my lady knows far better than I, has been they're flexible documents. They are not rigid. Their interpretation has developed over the years, and if that's an interpretation that Milady thought was appropriate to now consider in a case such as this, given the difficulties that arise, then that would be a matter for this court.
It would, but what is the international practice?
Well, it would be a change, my lord. I have to say it would be a change.
Where does one find? I mean, I keep on being told by everyone this is a received wisdom, and tectonic plates are going to shift and all that. Where do I find this received wisdom other than being spoken to me by people who, of course, I respect?
Could I say, I've been bothering about it ever since my lord raised it. I'm delighted that he raised it.
At the beginning of yesterday?
Yeah, at the beginning of yesterday. And now I know the third country case, but that's not what I'm talking about.
No, I understand.
And it's also the case that not every country adopted our position that you couldn't have a unilateral change in habitual residence. And it's fairly obvious that the Convention contemplates that there can be a change of habitual residence after a wrongful removal.
Yes.
Fairly clearly. And is still talking, and it uses this word, return. So, having raised this question, and I do think it's rather, we may decide we've got to duck it. We may. But on the other hand, it is sufficiently fundamental to the working of the Convention, and for that matter, to the outcome of this case, that having raised it, I think I would invite each of you to put in written submissions about it within a reasonable time. Just, you can tell us that I'm barking up a completely non-existent tree.
I'm not sure that's a submission I'd ever make.
No, say it was me.
Well,
it was a judicious bark, if I may say so. I mean, just to bring it home to the circumstances of this case, let us suppose that the view was formed that by the 4th of November 2015, the children were habitually resident in the United Kingdom.
Yes.
The actions of the mother on the 4th of November 2015 were, you submit, in breach of the father's custody rights. Now, in those circumstances, notwithstanding that they were habitually resident in the United Kingdom, could they be, or should they be, ordered to be returned to Australia?
Well,
that's the same question.
Yes, that's the concrete.
Yes. What does return mean?
well, Milady, I can on my feet deal with what my answer to the learned Lord Kerr's question, but I would very much accept Milady's.
Well, don't deal with it on your feet. If I may suggest you deal with it in written submission.
I
think that it will repay careful reflection.
Indeed.
Could you, for my benefit, take into account also the implications of the 1996 Convention, Articles 7, 6 and 7, because there, which that's dealing specifically with jurisdiction, and there, habitual residence does particularly bite on that,
yes,
and with the same tests. And if unexpectedly we reach the view that one had to send the child back to Australia under the 80 Convention, nonetheless, under Article 7 of the 1996 Convention, the jurisdiction might still be here.
That in those countries,
result.
In those countries that.
So I think it'd be quite nice, for my benefit, to see how they interact. I mean, obviously, not all countries are part of the 1996.
No, my lord, the interlocking of those.
In this case, they are, and they're obviously we need to see them together.
Indeed, my lord. I know my junior has taken a note of that.
I mean, well, it looks, again, as a newcomer, it looks at the 1996 Convention to some extent, the sort of plugging gaps in the 1980 protection using similar terms.
Well, yes. I mean, one consideration would be if that. I don't want to go too far down that path, but if the habitual residence was in this country, then how would the court here? How would the court deal with a summary return application? Would it deal with it under the convention, or would it deal with it under the domestic law once the child's habitual residence was
Well, it
Well,
depends.
most of the time, the previous country would retain, if it was would retain jurisdiction
Yes.
because of the exceptions to
Yes.
the gaining jurisdiction. So,
Surely the thread running through the Hague Convention, the 1996 Convention, B2R, is that it should be for the courts of the habitual residents to conduct the welfare inquiry. If, as a result of movement in the principle of habitual residence, we're now finding a change of habitual residence arising earlier, in this case, arguably arising in England, then the general principle would be it would be better for the English court to make the welfare inquiry. But as a subset of that, a welfare inquiry might lead to an early conclusion for return to Australia.
well, it might. It might.
It might, my lord. It might. And the only difficulty within that, my lord, is are we in a different position than we are in this case, where after such a significant period of time, finding of habitual residence occurs, and the children, particularly given the ages in this case, I mean, there may be different facts that would suit what my learned lord has just indicated, that would lend to support to a return. But on the facts of this case, it would be difficult to see.
Well, this is part of the difficulty, isn't it?
It is.
I mean, if one's looking at it in a very broad way.
Yes.
This is a prime example of the fact that the Hague Convention is designed to do something which may not be in the best interest of the children concerned. I'm not saying it's not in the best interest of the children. I wouldn't dream of saying such a thing.
No.
But it may not be, because that's not the issue. No. Just one final point on this ball that we have bowled to both of you, which I think is probably more damaging to Mr. Setterite than it is to you. Article 3 clearly contemplates that the child may now be habitually resident in a different country from the one from which the child was removed, at least clearly contemplates that, because it talks about the child was habitually resident immediately before the removal.
Yes, my lady.
And yet it clearly contemplates return to that country.
It does.
Which is why I'm puzzling about it, and maybe, well, I think we've said as much as we can say, and we are going to invite both parties, and indeed the interveners, should they so wish, to put in written submissions about this matter before we reach a final conclusion. We'll set a deadline. We'll think about the deadline and we'll set it at the end of the hearing.
There have been some cases, haven't there, quite a long time ago now, when the rights of custody were attributed, certainly by English courts, to the court system
Yes.
in the country from which the child left. Is that right?
Yes. Yes, my lord. And of course, Article 3...
On the basis that the rationale was that the state of habitual residence at the time of the wrongful act was the state where the decision had to be made.
Yes.
Well, as Lord Wilson says, the welfare, that's where the welfare inquiry is to be had. And that's why it's a summary return,
Yes.
rather than a return on the basis of where the welfare of the child indicates. The state where the child is presently found stands back from the welfare inquiry in favour of the state of habitual residence at the time of the wrongful act. That's the really very simple rationale, isn't it, of the 1980 Convention?
Indeed. It really is. And for a very long time, we've talked in terms of state to state, rather than, of course, from parent to parent.
Right.
My lady, my learned junior alerts us to back to the Perez report
Yes.
on this issue
Yeah.
at MS page 887, paragraph 110. Now, I don't know whether my lady wants some time to reflect on that now, or whether... it may be that it should really be considered within the submissions.
Well, that's about as unhelpful as it's possible to be, isn't it?
But it is the paragraph within the explanatory notes
Yes, which deals with it.
It says that they deliberately didn't include a reference to return to the place of habitual residence. But quite what was the alternative is not very clear.
Well, it'll need more consideration, my lady, I'm sure.
Well, it refers to return to the applicant,
Yes.
but subsequent case law, I think, in many countries has said, no, it doesn't necessarily mean return to the applicant.
Indeed.
For the very obvious reason that the applicant may be completely unsuited to look after the children.
Absolutely.
But it's nevertheless important that the children go back to the place from which they were taken. So, I mean, this is confessing that it's another of these problems that they fudged. Is it not?
I'm not sure I'm in a position to say that word, my lady is, but certainly that's the paragraph, isn't it, within the report which deals with this particular
Well, we're very
area.
grateful to that, but nevertheless, I still would like your considered submissions on this
And my lady will have
tricky point, because the one thing that is not so satisfactory about oral hearings is we get a lot thrashed out in oral hearings, but sometimes things come up which really require people to think about carefully and not just on the hoof. Now, you've not got much longer, Mr. Hill, and we have taken up a lot of your time with our questions.
Indeed. Well, happily, my lady, I wasn't intending to be an hour because
Yeah.
my learned junior was going to deal with ground 3, and I
Yeah.
have the strongest understanding from your indications yesterday that that is not a ground that you would wish to hear submissions on.
Well, no, we said we'd hear from you.
Yes.
No, what I said was that we had no great enthusiasm for it.
We said we had for the cross appeal. We had
That's the cross appeal. That's what we're.
ground 3.
Yeah, ground 3 is different, but we haven't really heard anything on ground 3, and they're both different aspects of the factual decisions.
They are,
Let's hear from your junior on ground.
We'd like to hear from your junior anyway.
well, it's a different junior.
All the better for that.
Well, not necessarily better.
Well, not necessarily better. No, none the worse for that.
Yes.
No, it's,
Well, yes. So, forgive me. My lord has said that he's interested in ground 3, but he's not so interested in the cross appeal. You have both, but Mr. Setright didn't really address us on ground 3, so he's going to have to come back on that in reply. And similarly, if you want to persuade us to entertain your cross appeal, well then, fair enough. But they are both factual
Yes.
conclusions
For my
reached by
part,
the trial judge.
I would like a little assistance on both. But,
Yes.
we've got what's in your case.
you have in our written case, my lord, is the position in terms of both. You'll have seen, I'm sure, the reason for the cross appeal, but in terms of
But is ground 3 relates to November, does it?
it does.
Yes, and I think it'd be helpful to see what's said about that, particularly having regard to the.
Yes. Well, can I then try and deal with it, if I may?
Because here you're asking us to interfere with the findings of the trial judge.
Well, we are, my lord.
No, he's defending.
Well,
The argument is that the majority had no business to interfere with what they regarded as the finding of the trial judge about habitual residence. But the majority did interfere with it to the extent of saying that the November evidence had not been properly appraised.
yes.
And if properly appraised, might lead to a different conclusion on the date of retention.
Yes.
Yes, we've got two separate factual issues. One is the date of retention, and the other is habitual residence. Your cross appeal has to do with habitual residence. You're defending an attack on the majority of the Court of Appeals disagreeing with the trial judge on the date of retention point.
Well, whether you want to hear from Mr. Setright first in terms of the ground 3 before you hear from me, my lady, that's of course entirely a matter for the court.
Let's hear from him.
We'll hear from you. And then if it occurs to us that there's any unfairness been done to you by letting Mr. Setright have the last word on this question, you can have the last word.
I'm not so precious. My lady, thank you very much. Then in terms of ground 3, then the court needs to consider the ground, of course, if the court accepts that wrongful retention, as it's described, anticipatory retention, is a legally binding principle, and that uncommunicated intention can form the basis of wrongful retention, anticipatory retention. Our submission, of course, is that the majority of the Court of Appeal were right to disturb the findings of His Honour Judge Bellamy. In particular, the Court of Appeal were correct to disturb His Honour Judge Bellamy's finding that the mother had not intended to retain the children in November, February, or indeed in April.
Well, what they actually said was that he'd never really applied himself to that because he took the view, that the fact that some sort of application needed to be made to the Home Secretary anyway was a sufficient answer to the suggestion that the November letter was an indication of repudiation.
And the learned majority below took the view that there was no logical way in which the evidence could support that finding.
Yeah, but supposing he did make that mistake, what was the evidence about what her state of mind was as at November 2015?
Well, I took my lords to that yesterday.
Not the letter.
The letters and the statements.
And what did she say?
In support.
What did she say? Yes,
well,
we've seen all those. What did she say about it?
What she said in cross-examination, my lord knows, was that by April, she was sure that she wasn't going back.
She certainly said that, but as was she not asked specifically about November?
She was.
And she said?
Forgive me, my lord.
I think you'll find it at about 624 or thereabouts. Just find it.
Very grateful, my lord.
Between 624 and 630, my note says, but that's rather wide.
Yes, when she was taken to the letter written to the Home Office, which of course was the 4th of November,
Yep.
She was then asked about that. Dr. McLean's evidence, of course, in support.
Yep.
It's very 629 and 30, isn't it?
629, is it?
But it gets rather muddled up with an argument about whether you said no N-O or no K-N-O-W.
Yeah.
But I mean, at the top of 630, she was specifically put to her, you had decided you didn't want to go back. No, I hadn't.
Yes.
Right. Now the question is the judge entitled to accept that or not?
No, my lord, not in relation to the totality of the evidence. He wasn't. And we say it was plainly wrong because his interpretation of the Home Office evidence was wrong.
Well, he's wrong when he says that the fact that some application had to be made to the Home Office is an answer to the point. But was he or was he not entitled to believe her when she said, in effect, I was in a state of flux, I didn't know what I was doing, it wasn't until April till I made my mind up?
Well, I have to answer it the other way around, my lord. If he got the interpretation, with great respect to the judge, in respect of the Home Office evidence, right, he might have been.
Oh, I see. All right.
Well, your submission must be, surely, that he dismissed the contemporaneous evidence as being irrelevant because of two factors. First, because she had to apply to extend the visa period, and secondly, because the children were entitled automatically to British citizenship. Yes. And therefore, your submission, I assume, is that he didn't give consideration to the significance of the evidence contained in the statement of the appellant and the supporting documents. I mean, whether he would have reached the same conclusion or not is neither here nor there in the opinion of the majority. That evidence has to be considered for the significance that it inherently had.
Absolutely, my lord, and that, of course, was the position of the majority of the Court of Appeal on this point. And
Could it be, Mr. Hale, that the judge wasn't really assisted by all that penetrating cross-examination on behalf of the father, of the mother, in relation to these documents? Now, madam, let's look at this, shall we? Let's go through it line by line. And you tell me if it's untrue, and if it's untrue, why it's untrue,
yes,
and how it came to be written. I don't find any of that in the transcript, which we've read overnight.
Well, my lord, the evidence that I alerted the court to yesterday at MS page 558, it cannot be doubted, I'm quoting, it cannot be doubted the children's centre of life is and will be in the UK where the children are registered as requested, had nothing to do with their rights for a British citizenship and passport, had everything to do with the mother's intention and her view as expressed through her solicitor. So, my lord, I understand my lord's criticism, but whether it needed to be put when it was as plain as a pikestaff in that part of our own evidence is another matter. And
That's the way it was submitted to. I mean, do we presumably have somewhere here the submissions that were made to the...
You do, my lord. You have my learned junior's submissions. You have both junior's submissions on...
And, I mean, the judge quoted that bit of the letter, so he clearly had it in mind.
Well, he did, but again, we go back to the point that my learned Lord Kerr made. It was the way in which he looked at that letter, we say, was illogical.
But except that the mother has said, being cross-examined on this, the letter is put to her, and it says clearly you had decided not to go back, and she says no. And the judge apparently believed her. Well, that's his job, isn't it?
Well, I go back to the answer I suppose I gave to my Lord Hughes a moment ago. That would be fine if, in terms with respect to the learned judge, he had looked at the evidence of the Home Office and the statements around it, but particularly that letter.
But he did, he quoted it. Well, I mean, the trouble is, both sides were blowing hot and cold. I mean, in most situations they do. The father was trying to, from his emails, trying to say, well, look, take your time, make up your mind, I want the children to be happy and so on. And the mother was clearly in two minds. And then we have this rather surprising letter from the solicitors, which takes a very strong view, no doubt for reasons which they thought were the best way of getting her continued residence. But and the mother is asked about that and expresses her view. Why is the judge not entitled to accept that?
Because it's to suggest, my lord, that what was said on her behalf was a lie.
Well, it happens.
But
Solicitors have occasionally over-egged the pudding in order to...
But that's not what the mother had said. She didn't say that the evidence that's been promoted on
anyway,
my behalf...
there it is. We've got the material.
You can really only say this was prima facie arresting evidence, which had to be grappled with.
It had to be. And
Yes.
grapple, my lord, of course, was the word used in the court below, and I refer, my lords, of course, to MS page 206, paragraph 180, with the judge failing to consider and address the key issues. So, as the learned lady justices say, the key issues, whether the circumstances surrounding the children's application for British citizenship amounted to an anticipated retention. So once he had determined, my lords, that the principle of anticipatory retention did not apply, his interpretation of the evidence then flowed from that, we say. And that respectfully is in encapsulation of our submission on ground 3, that once the die had been cast or the ink had been blotted, that actually from that point, his interpretation of the evidence was geared towards that not being evidence of a retention because the principle of wrongful retention wasn't a concept. So my lord, those really are the submissions on ground 3. The analysis, as challenged by the learned lady justices is within the judgment. His failure, as we say, to grasp the importance of the documents was ably described in the court below, and we urge the court to accept that as the correct analysis of the failure by His Honour Judge Bellamy to deal with that evidence properly. But it really, as I say, and please forgive me for the repetition, it came from the careful determination that he took to start with that wrongful retention, anticipatory breach was not a principle that he could rely then upon. And that fed then to the second part, which we say was not a logical conclusion, and that is that even in April, he could not find a date of retention. And this is to my Lord Hughes's question in terms of the mother's evidence. She herself has accepted that by April, she had intended not to return the children to Australia. Now, the learned judge at first instance determined that that was too imprecise to be relied upon. Well, we, of course, rely upon the majority of the Court of Appeal in that respect, in not agreeing with the first instance judge, and the paragraph is MS page 208 at paragraph 186, where the learned lady justices say that the judge repeated his earlier observation that it's settled law that wrongful retention is an event and not a process. And he was therefore referring, of course, back to Lord Brandon in Re H, dealt with by Lady Justice Black, paragraphs 30 to 36 in the above judgment. The judge went on to say, a finding that there was a wrongful retention on some unspecified date in April is, quotes, too imprecise. This seemed to us to be wrong, both as a matter of law and in logic. In our view, if an event occurs in April, but it cannot be attached to a particular date, it does not follow that the event did not occur or did not occur in April. Had the evidence supported such a conclusion, a finding that retention had occurred by the end of April would have been perfectly permissible, and they might have gone on to say perfectly precise.
Well, you're saying it's sufficiently precise to say, I can't give you the exact day, but it's not later than.
Yes, my lord.
Whatever date it is.
And as the Lady Justices said, that the preponderance of evidence could easily, my words not theirs, could easily brought a conclusion from the judge at first instance that by the latest, the 4th of November, was the date of wrongful retention, for all the reasons I've already explained to the court. And so that was a fundamental failure, we say, that in fact it was a misunderstanding of the seminal speech of Lord Brandon in Re H, matter that Lord Hughes dealt with elsewhere, in terms of there not needing to be, of course there needed to be precision as to a timing, but where a judge is faced with possibility of 3 dates, because there are, say, 3 or 4 dates, that doesn't mean that the finding that one of them is the correct date is imprecise. It's simply a finding of the judge on the evidence.
Yes.
Conscious, my lady, of the time.
Well, Mr. Edwards, we may want to hear from Mr. Edwards on the cross appeal.
Well, my lady,
briefly.
Mr. Edwards wasn't prepared to deal with the cross appeal.
Oh, he was going to deal with.
If you remember, I had a.
Now, I couldn't remember which was which. Yes.
Renton was again.
Yeah, yes.
Miss Renton was.
Yes.
Was
And
not
she,
able
of
to
course,
be here
did the
this
trial
morning.
below. So.
Yes. Yes. Well, is there anything you'd like to say briefly about the cross appeal?
Well, certainly. Can I refer my lady to? I think the simplest thing I can do is take you to our written case in respect of the cross appeal, which appears at MS, page 143. And, my lady, I immediately accept that these submissions are based upon the the unusual circumstances of this case in terms of the judgments. My lady, I'm sure, will have seen, my lords will have seen that in terms of the submissions about the cross appeal, that His Honour Judge Bellamy at first instance had failed initially to deal with the question of habitual residence and had to be reminded of that matter, as I understand it, and then dealt with it in his, I think it was an extempore judgment which was written and then provided, or rather a written judgment that was given extempore. And that error, my lady, actually found its way through also to the judgment in the Court of Appeal, unfortunately, because at the time that the judgment was finally given 3 months after the hearing, the fact that habitual residence was a ground of appeal by the appellant father had not been dealt with within the judgment. So the overall, in terms of the cross appeal, forgive me, I took you to the wrong page, forgive me.
That's paragraph 83, doesn't it?
It does, my lord, forgive me. I'm sorry, I went to the conclusion rather than to the start. But it does start at paragraph 83 indeed.
So in a sentence or two, why was the judge not entitled to come to the conclusion that the children were habitually resident in England and Wales on 28 June 2016?
Because, my lord, the having come to the erroneous conclusion that anticipatory retention, wrongful retention, didn't apply, was not a principle that he should apply. He then interpreted the evidence, we say wrongfully, in terms of habitual residence.
Where was the error? The two are quite distinct. Retention, one thing, habitual residence, another. He turned to habitual residence. Where was the error on that?
His analysis of habitual residence did not include, my lord, the careful, and I'm now looking at paragraph 86 and 87, my lord's expectations in 88, the expectations in terms of the assessment, what might be described as the holistic assessment of habitual residence, were not found within this judgment. There was not an assessment that in particular dealt with the child's position in Australia, the fact of the left behind father and the paternal family did not, we say, form a sufficient part of the analysis. The deeper, as my lord said in Re B, I'm now looking at page 139, paragraph 88, the deeper child's integration in the old state was not part of the analysis of habitual residence. The greater the amount of adult pre-planning of the move existent, the fact that the conceit, as we say, my lord, that the evidence of November the 4th and the Home Office, those factors didn't weigh, we say, at all properly in the assessment of habitual residence. And I go back to my point, that's because the learned judge at first instance, his logic in respect of that evidence was flawed. So he didn't see it as evidence upon which in the assessment of habitual residence, it should have formed a very large part. If in fact he'd found, my lord, if he'd found that evidence was evidence of the mother's intention, as we say it should have been, to wrongfully retain at that point, that should have had an impact on the assessment of habitual residence.
In what way?
Because it was entirely inconsistent with the case that she was putting before the court. It went to her credibility, yet it also went to the fact that after the November point was only 6 months into the agreement.
Yeah.
And had he properly assessed at that point that evidence, we say it would have been evidence in the assessment of habitual residence, which he should have considered this to be a mother who was forcing roots, rather than there being a natural development of habitual residence in this jurisdiction.
I mean, I understood you really making 2 points, which are those set out at 93.4 and 95, which really, 93.4 is a sort of circumstance of what was intended as a temporary relocation by one parent.
My lord, absolutely.
And 95, you say it was one-sided. It looked at the mother's point of view, but not the father's.
That's the holistic assessment that didn't take place. And the fact of the breach of the agreement, we say, should have been a very significant part of the assessment process of habitual residence, because it was, we say, significant to the child that when these parties first agreed, this child was returning. It's a circular point, of course. But having breached that point, the intention of these parties when these children left the shores of Australia was that they would be brought up and returned to Australia. And that didn't form any proper part of the analysis.
Right. Thank you.
My lady, does that, I hope, deal with the cross appeal?
Yes, it does indeed. Thank you very much indeed, Mr. Hale. And we understand that Mr. Edwards does not wish to add anything. You've already been very helpful, Mr. Edwards. We understand that. Thank you. Mr. Seth.
My lady and my lords, last things first, I have the advantage of the assistance of Mr. Gratian, who was, as the court will have seen, junior counsel, and subject to the view of the court, I've agreed with him that he should, and he would be most happy to do it, deal with the factual matters which are the foundation of ground 3 and of the cross appeal. And so I will confine my, and probably about 15 minutes will suffice, he believes, for him to deal with that adequately. What I will deal with in the half hour or so that I then have are some other matters, but I'm conscious of the fact that the court has indicated a desire to receive written submissions. And it's going to be completely pointless for me to provide extempore thoughts on matters that are then going to be at best expanded and at worst contradicted by those thoughtful submissions. So shall
Quite
I
right,
see
Mr.
how
Setright, quite right.
shall I see how I go and try not to tread on my own toes, as it were?
Well, you've plenty of other things to tread on.
I think I've or dance around, my lady. So I shall try. Back to some fundamental principles. Wrongful retention has two elements. A, retention, which is a question of fact, arguably, and B, wrongful, which must be a question of the application of some law. If I'm not being simplistic, even at this early stage in my reply. And second, and I'm not sure to what extent that is now accepted by my learned friend, it is an event and it is not a process. To some extent, well, my learned friends were candid in saying at one stage in these proceedings that they didn't accept that it was other than a continuing process. H&S is very clear, we say, and unless this court was going to go back on what the House of Lords said in H&S, it is an event, and it must be a definable event.
Is it permissible to define it as not later than?
That's a sort of indictment point, my lord, going back.
But is it permissible or not?
Provided there is a precision.
Okay.
It's really a question of evidence combined with definition. And the old form of indictment on a day or days before X, which was once commonplace, meant that the prosecution still had to go to the evidence upon which it was based. The H&S requirement that there is an event is at least in part a product from it being the earliest date. The parties can't, that's the product of H&S, decide to choose the most convenient date to them, there will be one event of wrongful retention, and it's definable, whether it can be defined as on a day or days between the 1st of April and the 30th of April 2016, or whether it must be defined as being on a particular date, maybe isn't of critical importance. What is of importance is that unless it's pinned down as a fact, it doesn't really work.
But I mean, as I understood Re-H, and of course you were in it, so you know best.
Long time ago.
Yes, I mean, there are two things. One, because your date, Article 3 requires you to see what was written immediately before the date.
Yes.
And Article 12 introduces the idea of a year from the date.
Yes.
So, in a way, saying not earlier than that or not later than that doesn't fit with one of those.
Not work, my lord.
No, I mean,
that's right.
In practice,
That's why I was...
I mean, in practice, you may be able to say, well, it was in April, it was a defined date, but we can't actually put it on. But the construction of that, the convention seems to me, and I think this is what the House of Lords were saying, to assume a single event.
It's a contextual construction, exactly as my Lord Conway says. And that's why I was probably unhelpfully equivocal in my answer to Lord Hughes. It may be that it won't particularly matter, but in fulfilment of the requirement that it has to be seen in the context of the balance of Article 3 and Article 12, it is quite likely to be necessary to pinpoint an exact date.
And the other curiosity is that it's the retention. It's not when it became wrongful. You have to pinpoint the date of retention because it's immediately before that you to find out what is the law by which you assess whether it's wrongful.
Well, I'm not sure that's right, is it?
Well, it's what the section says. I mean, it may not make...
It says what as I read Article 3 at least, what it says is what matters is habitual residence immediately before the wrongful retention. But is that wrong, Mr.
Immediately before the retention. It's by reference to that law that you decide whether it's wrongful.
We'll argue about
But
that.
I wonder if it's appropriate to break down wrongful and retention. I mean, retention surely connotes something other than the discharge of parental responsibilities. I mean, it seems to me that the mother, while she's abiding by the terms of the agreement, isn't retaining the children. She's simply keeping them in her custody in discharge of her parental obligation.
Well, my lord, with great respect, I'm not sure I would agree.
Well, I'm completely ignorant in this area of law, and I'm prepared to be educated by you, Mr.
My lord, I'm not prepared to accept that your lordship is ignorant in the tiniest degree. But, my lord, if one looks at retention,
Yeah.
and if one says retention is a state, a fact, wrongful is something that characterizes a retention. A retention, therefore, is the act of retaining a child in a jurisdiction, a lawful retention.
I see. So from the moment that the mother took the children to the United Kingdom, she was retaining them, was she?
Oh, yes.
I see.
Well, I'm not sure that works.
Well,
That's
it works
I
if
mean,
one-
it makes sense.
Perhaps we can have our own private
I think we better have
battles later. There's clearly a potential difference of
If
view in
indulged,
this.
if indulged,
You
for a
carry on
second-
with your submissions.
If indulged for a second, it works if one adopts my Lord Hughes's approach,
Yeah.
because then the retention, which can be a continuing state, there's a retention every day for the year.
Yeah.
It becomes wrongful at a particular point.
Yeah. Okay.
But it is like many areas, some wholly unexpected, that have been covered in the oral part of this appeal. It's of great interest. So back to my submissions on the indication of the learned president. But we do say that H&S is seminal, one way or another. It probably bears fairly close examination. What it can't justify, we say, is any imprecision as to the date of retention and as to what the retention was. And it goes a little bit further than that. It must be an encouragement to courts in the context of the 1980 Hague Convention to take the view that wrongful retention is a matter which must be treated with firmness and precision. If it isn't, then, and this is a rolled up reply, the consequences for the smooth running of the 1980 Hague Convention, and I don't just mean the smooth running of hearings and the smooth running of a summary hearing which avoids an evidential process of discovery, is rendered rather difficult. So we would say, tentatively, that one must determine the point of retention which may be a wrongful retention, something which is a candidate for being a wrongful retention, and then look to see whether that is wrongful in terms of the law of the state of habitual residence in accordance with Article 3. That submission, as your my lords will all have discerned, is something of a fudge within itself. We have tended, having looked at the words, to think also in terms of not merely premature retention, but perhaps preemptive retention. But I'm not sure that playing with words is the best service to the court at this stage, because I suppose it might be said that if that which is proposed by the majority or by the entirety of the court below is right, it is treated as preempting in that it's effective as of the date of, according to Lady Justice Black, as she then was, communication, according to the majority, perhaps expression or even formulation of thought. It's effective as of that date rather than as of the date that the agreement is actually breached by an unauthorized retention after the date of return agreed upon. We say that putting it in that way highlights the unattractiveness, as we see it, of what is suggested. And my lady and my lords, we also would refer the court to the passage in the Perez-Vera report, which is at MS 886, at tab 6, I'm grateful.
Page again?
886, the court's already been taken to that by Mr. Hale, but he didn't take the court to the concluding part over the page at 888, at paragraph number 112 of Professor Perez-Vera. And that probably puts it in context to some degree. My learned friend made the interesting suggestion that in order to operate the inherent jurisdiction to provide a route to a summary return, one would have to demonstrate that there wasn't an habitual residence. Well, my lady and my lords, that slightly perplexed us. Physical presence is the usual basis on which the court moves in the inherent jurisdiction. In a non-convention case, to contemplate a summary return, and it's usually then still, but not always, a return to the country of habitual residence. the court wouldn't particularly be bothered, I suspect, about habitual residence if it was in the overriding best interests of the child in a situation that was otherwise meriting a summary return. But it might think very carefully and hard if habitual residence had moved, which was a point made by my Lord Hughes. But if one looks at 112, finally, Article 18, one of the few articles, my lady and my lords, that we haven't covered so far in this appeal. Article 18...
Oh, we haven't covered Article 13, which is such a relief.
I thought I'd mentioned it.
Yeah.
Well,
I think you did.
I think I did.
covered, I think not.
Yeah, well, don't start now.
Article 18 indicates that nothing in this chapter limits the power of a judicial or administrative authority to order the return of the child at any time. There's been a debate about Article 18. It's the consensual view in this jurisdiction that it doesn't provide of itself a freestanding power, but what it does is to provide an access to other aspects of the domestic law. The professor goes on, this provision, which imposes no duty, underlines the non-exhaustive and complementary nature of the convention. This was in 1980. One can say that is true in excelsis in 2017. In fact, it authorizes the competent authorities to order the return of the child by invoking other provisions more favorable to the attainment of this end. This may happen particularly in the situations envisaged in the second paragraph of Article 12, i.e., where, as a result of an application being made to the authority, after more than a year has elapsed since the removal, the return of the child may be refused if it has become settled. Now, that's not an answer to my Lord Hughes's question asked of my learned friend Mr. Hale, which he didn't feel able to answer, which is, have there been cases where an Article 12 settlement has been found and nevertheless there have been a return? Professor Perez-Vera provides a possible answer, but that's only an example. Equally, the Article 18 example could apply very well, if welfare merits it, to a case like this. We can answer my Lord Hughes's question, which is that there are no cases in the authorities. We know of a case many years ago heard by Mrs. Justice Black, as she then was, in which she made an order for a return having found Article 12 settlement, but then suspended it, and in fact the child was not returned. Suspended orders for returns are a very unusual thing indeed. And so the generality of it is, if settlement is demonstrated, it is manifestly extremely unlikely that a court will order a return, possibly even more unlikely than if an Article 13b grave risk of physical or psychological harm or intolerable situation is demonstrated and can't be remedied by protective measures, then it is very unlikely that there will be a return. We say that emphasizes that there really isn't a need to have a broad, all-embracing interpretation of the 1980 Convention, including as a device to try to prevent deceit. One, because the 1980 Convention is not intended to be comprehensive and all-including, and two, because it specifically endorses that there may be other ways of achieving its end, specifically including a return. And therefore, if a court forms the view that for technical reasons the 1980 Hague Convention will not work in a particular case, but nevertheless there is a compelling reason why the child should be returned, it will go on and do so. And that is exactly what the Supreme Court did in the Texas case, which I have already referred to, where for technical reasons there most certainly wasn't an Hague Convention case, but the court had plainly formed, on the basis of such relatively limited welfare evidence as there was, the clear view that notwithstanding, I think it was 2.5 years in this country, there should be an immediate return, and there was, in the inherent jurisdiction. So before taking a decision which broadens the scope of the convention, I would invite the court to consider that when looking at the downside of so doing, it isn't actually necessary. Another point that I make, again, to some extent, it may be that the respondent's case has moved here, but my learned friend's position had been that retention could be the broadest possible range of events, ranging from a letter saying, "I'm very sorry, I won't be returning the child," that which would pass Lady Justice Black's test, to something which is communicated in another way, which is completely unequivocal, but doesn't necessarily come from the person, but is nevertheless almost inevitably documentary in form and demonstrable, with the date of retention being the date of communication, all the way down to thoughts, private expressions of view, not communicated, where these also form the date of the retention. Well, without going in detail into my Lord Hughes's assertions and the assertions of the rest of the court about an actus reus, it's hard to see how this particular convention, which at least in its in the form it takes in this country, has eschewed, so far as is possible, subjectivity in favor of objectivity in factual interpretation. What that does to the operation of the convention is almost, we say, unthinkable, and I don't resile from anything that we said in opening in our written case. It relates to the degree of certainty. It relates also to the operation, as the court has observed, of Article 12, and it's certainly not an antidote to dishonesty and manipulation, which, as a lady, the President, said, I'm paraphrasing, is relatively rife in this particular area, unfortunately, because there'll be the same degree of manipulation to bring about an Article 12 settlement. And it will produce an unwholesome degree of uncertainty, an uncertainty only potentially resolved by a factual inquiry and probably a discovery process. Lady Justice Black was, with respect, absolutely right in the dangers she foresaw. Where there may be more difficulty is in her assertion that it's a matter of policy to deal with it. There's a strong argument it isn't a matter of policy. It's a matter of law in the purposive intention and the purposive interpretation of the 1980 Hague Convention that this court should not drop that Hague Convention into that situation, to which the answer is a narrower view and the allowing of the appeal on ground one. On habitual residence, and this is a point plainly different to the cross appeal. At one point during my learned friend submissions, my Lord Hughes asked whether, if there was an sabbatical or if a child was here for a period for an education purpose, I'm paraphrasing, that would mean that there would not be a change of habitual residence. We make the submission that in the light of the decisions of this court, and in particular following Re B, it is an aggressively factual concept, and in particular, temporary periods, and this is something which doesn't come solely from the English decisions, it comes from the Court of Justice. Temporary periods are capable of producing a change of habitual residence. Unilateral decisions are capable of producing a change of habitual residence. Both those things are now well understood by the judges trying the cases on a day-to-day basis. Of course, it makes it more difficult. And the analysis, the balanced inquiry, and I'm really not trespassing on Mr. Gratian, better be sure I'm not, is something that is important in those circumstances. But if a child is in a jurisdiction for, say, 6 months, and if that child is placed in school or preschool, and if that child is surrounded with all of the ordinary trappings of a day-to-day life, which is much more than that which might be seen living out of a suitcase on a one-week holiday, and if there is a commensurate pulling up of some roots in the other jurisdiction, which is the balance in my Lord Wilson's judgment in B&B, which is in B, which is critical, then one can have a change of habitual residence in those circumstances. Not will, necessarily, but not a presumption that one won't either. So that was the observation that we made about that. And with my lady and my lords, we had thought of taking the court to Article 7, something which I ducked in favour of Article 25 when my lady the President gave me the opportunity. But we say that my learned friend Mr. Hale, Article 7 does indeed provide a mechanism for a retained jurisdiction in circumstances. It's a mechanism which reads perfectly easily with our interpretation in ground one. It doesn't impede, of course, a change of habitual residence. Like the 1980 Hague Convention, what both do is to impede a change of jurisdiction, and that is the key. And we say, my lady and my lords, that if one looks at the preamble to Article 3 is not incorporated by our statute, the 1985 Child Abduction and Custody Act. We got the Article 3. It's under here. Oh, so it is. If I read, this is MS 773, the preamble. The state signatory firmly convinced the interests of paramount importance in matters relating to custody, desiring to protect children internationally from the harmful effects of their wrongful removal or retention, put together, and to establish procedures to ensure their prompt return to the state of their habitual residence, as well as to secure protection of rights of access. That is the way that it is put there. But I'm starting to tread on my own toes.
Well, you are, aren't you?
So I
and of
must-
course, there are difficulties of reconciling that with everything else.
There are. And if I was going to tread on my own toes again, I would take the court, I'm afraid, to B2A, which is the first point of jurisdictional access in this country, in our domestic jurisdiction, which has a particular treatment in Article 8 of habitual residence. But I think I'd better leave those for the written submissions. But I give the court a taster in case the court has questions that it may ask about that, because we haven't looked at B2A, but B2A, notwithstanding the fact that this is an Australian case, is of obvious significance. Mm-hmm. And if the court was going to do something bold about habitual residence, which cut across the interpretations in B2A, then entirely unexpectedly in this case, but then many unexpected things have happened in this case, I might be having to flag up the possibility of the Court of Justice if it was something really radical. But at that I will stop, and I will, if I may, turn to Mr. Gratian to see if there's anything else that I ought to deal with, and then, subject to anything the court asks of me, give way to him. Anything else? Right.
Thank you very much, Mr. Sedgwick. Mr. Gratian.
Lady Mollard, somehow I expect it will always fall to junior counsel to deal with matters of fact 15 minutes before lunch. So I will try and do it as briefly as I can.
And would you like a lectern to assist you, or are you...
My lady, I think that might require too much manoeuvring of the papers on the desk. Oh, well, there we are. And now there are only 30 minutes before lunch, so it saved some time. My lady, I think the clock on my computer is slightly fast. In relation to ground 3, as a starting point, of course, the approach of the majority of the Court of Appeal when challenging and eventually setting aside His Honour Judge Bellamy's factual finding about the November date was the letter. That being said to be so important that it cast doubt upon the conclusion that he reached. Of course, when one looks at the letter, 2 points I would submit immediately come to mind. The first is that it was not a document prepared by the mother, but by a lawyer instructed on her behalf to make an immigration application. So it had a particular purpose, and it was directed towards that purpose. The second, which follows from that, is that the purpose of the letter was not a statement of the mother's intention as to what she may or may not do in June of 2016. It was directed towards meeting the requirement of the case that the lawyer felt turned out incorrectly he had to meet in order to obtain citizenship for the children. And the consequence of that, I would submit, is that when one considers the terms of the letter, whilst it does make reference to the children staying in England and other matters in relation to their interests, it doesn't say anywhere within it that the mother doesn't intend to return. And the same is true of the supporting documents. They make reference to the children's situation in England at the time when they were prepared, in September of 2015. But they don't make any reference to what the mother may or may not have been intending to do later.
Would anyone reading those documents get the impression that the mother intended to return to Australia?
Well, my lord, they simply don't deal with it, one way or the other. I take the point. One can look at the documents and form an impression that it's intended that the children will remain in England at least for the long term, and that was the case as it was put on behalf of the father at the trial. The mother, of course, said that her intention was different. She didn't accept, and has never accepted, that that letter betrayed an intention on her part at that stage to retain the children when the expiration of the agreement came around. And so the question arises, how was His Honour Judge Bellamy to deal with the two competing questions? And what he was invited to do by both counsel was to hear oral evidence and to hear the mother give evidence about what she intended. And that as we've seen, and we've looked at the transcript of the cross-examination of the mother, is what happened. And the mother gave her answers, and she explained in some detail, really, her position. I don't think it's necessarily helpful or a good use of time to go through a great deal of the cross-examination that was conducted, but I would like just to give a couple of references to give flavour, particularly at MS 626. The mother was asked, on behalf of the father, whether, in effect, what she had done when making this application was to act on advice that she had received. My learned friend Mr. Hale has referred to, forgive me, the infamous, as he described it, letter from the Australian psychologist. It was suggested that she had...
Where are you reading? I got 626.
Well, it's 626, the top third of the page. There is a question, you acted on that advice to not return to Australia.
And the advice is the psychologist,
The advice is the psychologist. This is direct reference to the letter from Doug McLean. And the mother's response was no. I had to apply for something for us to be able to stay in the UK for the year. Something had to be done. So she gave an explanation in response to a specific question as to what she was intending to do by the application that she made. And her evidence then continues at 629. Miss Renton said to the mother, "It's about what you said to the Home Office. Representation suggests that you were not returning to Australia and you were staying in England. It's not caveated with only for a year am I in England, is it?" The mother accepted no. And then Miss Renton asks about the references. It's suggested that they give the same impression. The mother doesn't accept that. It says they indicate how settled the children are. And then the reference to which my Lord Carnwath has already made reference on MS 630 at the very top of the page, and you had decided that you didn't want to go back, and the mother said, no, I hadn't. So, lady and my lords, the mother had been asked about what she intended at this stage, and she gave an answer. She had been asked about what the intention of the letter to the immigration authorities was, and she had answered that. The question is, and I would agree with this formulation again, given by my Lord Carnwath, whether His Honour Judge Bellamy was somehow not entitled to accept the mother's evidence in relation to it. But if what is being looked for is an intention, and the mother has been asked to give oral evidence as to her intention at the time, has done so and has given answers, how, I ask rhetorically, can the judge really be criticised for taking that evidence, for accepting it, and therefore for holding that November was not the relevant date? Our submission is simply that he was entirely entitled, having heard the mother give evidence about it and having weighed it up, the mother having been closely cross-examined as to the point, to accept what the mother said. And of course, the mother's evidence didn't stop there. It continued, and she was asked about April. And April was a significant date because it is in relation to the date of April, as relied upon by the father, that the mother said she had felt that she and the children wouldn't be returning. And that is incorporated within His Honour Judge Bellamy's judgment at two places. Firstly, at MS 219, paragraph 34, and then again at MS 227, paragraph 62. Now, my lady and my lords, accuracy in relation to this aspect of His Honour Judge Bellamy's conclusion is important. This particular phrase, as used by the mother and adopted by the judge, has been put in various ways by Mr. Hale on behalf of the father. It's been described as a decision, as an intention, as a resolution. that by June the mother would not be returning with the children. But that isn't how she had put it, and that's not how His Honour Judge Bellamy had taken it. And it is
Can we
clear.
just look at paragraph 34 very briefly, final sentence? By April she'd felt we wouldn't be going back. Is that a finding, or is that a quotation of her evidence? You see the inverted comma at the end.
Yeah.
Where's the inverted comma? Is there an inverted comma at the beginning of that sentence?
There is before felt.
Before felt.
Oh, felt, right.
My Lord,
That looks rather like a quotation of her evidence.
it is.
doesn't
It's a quotation of the mother's evidence.
62.
And at paragraph 62,
Yeah.
the quotation appears again. This time the inverted comma is before by rather than before felt, but that's of no moment.
He does seem to say in 62 that the reason why there isn't a wrongful retention in April 2016 is that it's too imprecise. Is he right about that?
My Lord, I would submit that he is right about that, because as the mother has expressed it, it was by then a feeling. It was not a decision. She had not formed an intention. So that's why I'd submitted that the language is important. There's a distinction in terms of how it fits.
Yeah.
Even on the way that the father's case is put before this court, a feeling would, it seems, be insufficient. There must be a decision capable of breaching the custody rights of the left-behind parent. If a parent has simply began to feel that something may happen, that cannot, we would submit, be in any way sufficient to meet the father's case, even taking it at its highest as it's now put. So, my Lord, I would submit that for that reason it is too imprecise, but if I had to fall back on it, I would also submit that it is too imprecise to meet the definition as formulated by the House of Lords in Re H and Re S.
Well, that seems to be what he's saying, isn't it? Settled law, wrongful retention is event, not a process. April 2016, too imprecise.
Yes.
Yeah.
My Lord, however it's taken, the result on our case would be the same. There's a further significance, though, to that conclusion, which is that if it was only by April that the mother had begun to feel that she wasn't going to go back, it seems inconsistent with any conclusion that in November she had resolved that she wouldn't. And finally, on this point, the second criticism that was made of His Honour Judge Bellamy by the majority was that this particular conclusion, based on the mother's evidence, appeared at the earlier point where the judge was reciting the background and therefore didn't, put it in a slightly different and probably less accurate way than the majority did, appear within the meat of His Honour Judge Bellamy's judgment. But one can see from its appearance at paragraph 62 that that simply isn't correct. It's there in the judgment at the point where the judge was considering the factual situation as at the various dates contended for by the father. Now, my lady and my lords, I'd move on now very briefly, mindful of the time I have left, to deal with the cross appeal, unless there's anything else on ground 3 that you would ask that I deal with.
Please don't carry on.
In relation to the cross appeal, the assertion is that His Honour Judge Bellamy was wrong in law, most particularly because he did not specifically recite and apply the factors identified by Lord Wilson at paragraph 46 of the judgment in Re B. It's probably necessary only to make reference to this. It's at page 1166 of the memory stick. But of course, the expectations that were set out at paragraph 46 are preceded by the qualifying sentence that in making the following 3 suggestions about the point at which habitual residence might be lost and gained, I, Lord Wilson, offered not sub-rules but expectation. The impression seems very much to be that they were not suggested as some sort of test, that in every case the trial judge would have to incorporate into their judgment and specifically address.
You're right about that, Mr. Gratian.
But the implication of the father's submission on this cross appeal is that a trial judge would have to do exactly that. If it is not a test or a set of rules, it cannot be necessary in every case to set them out and to go through them. And just in relation to that, and only by way again of reference, on the first morning of this case yesterday, we handed up copies of a judgment of Lady Justice Black, as she then was, in a case called Reed J, a child Finland habitual residence, and there flagged in your copies are 2 paragraphs that deal with this, and her interpretation, consistently with my lord's, that this was not intended to be a test or a set of hoops that a trial judge must in every case jump. The second criticism is that His Honour Judge Bellamy had not adequately addressed or addressed at all various aspects of the father's evidence in relation to the habitual residence of the children. I'm afraid that I probably now have to resort to doing what Mr. Setright suggested we may have to yesterday, which is to give really a series of references to show where the evidence was and how His Honour Judge Bellamy took it into account. I hope I'll be forgiven for that. The father's evidence in relation to habitual residence appears within his statement, his final statement for the trial, which is at pages 587 to 593 of the memory stick. I hope I do no disservice to that statement to really summarise the points, but it was basically that the children had travelled to England for a trip of finite duration pursuant to the agreement. He didn't accept that the mother was integrated into life in England and asserted that she had been misleading as to her intentions. He said that neither children had been entered into any formal education, and he made reference to certain family members that remained in Australia. The father did, however, give some important oral evidence about his impression of the children's lives in England. That appears beginning at page 557 of the memory stick. No, forgive me, that's not right. It's 705. I'm sorry about that. They are the father's answers to questions from me, but the overriding conclusion from them was that at least by August, the father's oral evidence was, and of course the father came to see the children in this country then, that the children were happy, settled and comfortable living in England with their mother. And when asked by me, he accepted that there was no reason on anything he had seen to believe that the children had been anything other than happy, settled and comfortable for the time that they had spent here. His Honour Judge Bellamy, as one would expect, incorporated a number of aspects of the father's evidence into his judgment. He made reference, of course, to the fact that the move was intended to be of short duration and extended by agreement. That appears on the memory stick at pages 215 to 216. The children had entered Australia on a visitor's visa, it's at 217, paragraph 22. They had clothes, toys and belongings remaining behind in Australia, 215, paragraph 11. And that the move had resulted in a change to the nature of their relationship with their father, 219, paragraph 35. Importantly, I would submit, bearing in mind the suggestion that is raised on behalf of the father as a criticism of His Honour Judge Bellamy, he did deal within his judgment with the assertion that the mother had been evasive or otherwise deceptive, and that appears at 225 to 226, paragraphs 56 to 58. And His Honour Judge Bellamy weighed, we submit, all of that up. And at paragraph 80 of the judgment, on page 232, he reached his conclusion. That paragraph ends in the following way: "I'm satisfied that as the months went by, the mother gradually came to the conclusion that she and the children should remain in England. She had reached that conclusion by around April, though it was not communicated to the father. The reality is that apart from their intermittent contact with their father by Skype, by 28th of June 2016 at the latest, and arguably much sooner, the children's connection with Australia was minimal. The roots in Australia had effectively been pulled up, and they have put down new roots in England." Considering the fact that he had incorporated into his judgment large parts of the mother's evidence and parts of the father's evidence, that was, we submit, a classic expression of the conducting of a balancing exercise in the context of considering transfer of habitual residence from one contracting state to another.
So although your client's evidence was that by April she felt they wouldn't be going back, the judge, I think in 2 paragraphs, goes further than that and says, I find that she had reached a conclusion by April that she would not go back.
Yes, he does reach that conclusion there.
So why is that not fit for a conclusion, an investigation of anticipatory retention if the principle exists?
Well, my lord,
And if it doesn't have to be communicated?
the communication is an important aspect of it, of course. It is an extrapolation from her evidence, which was a classic explanation of a feeling. If and insofar as he reached a finding that it was a conclusion, that might, if communication is not required, be sufficient. But it comes down to that aspect of the case. Does that answer my lord?
Well, I think it follows that if you're wrong on ground 2, you are conceding the need for a reference back, as per the majority's decision.
Lord, I don't think that we had gone beyond that. Yes, my lord, Mr. Setright points out rightly, it would be if we were wrong on ground 1 and ground 2.
If you're wrong on grounds 1 and 2,
Yes.
you concede the Court of Appeal was right
Yes.
to refer, at least in respect of April, the matter back for redetermination.
Yes.
Very well.
Lord, those are the submissions on habitual residence, my lady, my lords, unless there's anything further I can address on those.
I think not, Mr. Gresham. Thank you very much. Technically, Mr. Hale, this is an application for permission to appeal on the cross appeal,
It is.
with appeal to follow if permission granted. We
As
haven't,
for
of course, yet decided that.
My lady, the same position for grounds 2 and 3, of course.
This is true, but each side has had the opportunity of
Yes.
dealing with ground 3, whereas the cross appeal, you haven't had a reply.
Indeed.
Because we haven't yet decided whether we are giving you permission to appeal on that ground. But supposing just for a moment that we were, what would you say in reply?
I would give my lady some more references.
Well, that's very helpful. Why not give us some more references? It won't take a moment.
No, and they're helpfully recorded, if I may say so, by Miss Renton, if she's watching.
Miss Renton may be otherwise occupied.
Well, indeed. Can I give you these references in terms of the evidence?
Just give us some page references.
Indeed.
Yeah.
MS 595, 626 to 627. In terms of the documentation, 555 to 558. Then in terms of cross-examination and credibility of the mother, page 483, my lady, and pages 649 to 650.
Did you say 483?
I did, my lord.
Thank you.
Thank you, my lady.
Thank you all very much indeed. Thank you to everybody for their very helpful submissions. I know that many of the people are appearing pro bono, for which we are particularly grateful, of course. Thank you also to the interveners for their submissions, which we have, of course, received and read, and will reread, no doubt, in the course of our working out what to do about this really extremely significant case. One's thoroughly aware that as far as the individual parties are concerned, what matters is them, their families, and the eventual result. But they must understand that actually this case does raise some very difficult points of law, which we have to go away and try and work out the answers to. Now, I asked for written submissions on the issue raised, and as far as the order in which those should go, probably you should both be doing it simultaneously. I'm not quite sure who goes first, really, because this is a question from the court. So could I give you a fortnight? Would that be all right? I feel you're both sufficiently expert in this field to be able to turn to it quite quickly.
We would prefer, with great respect, my lady, 28 days, not least because there would be a certain amount of international inquiry that we would wish to undertake in the particular circumstances of this case to give the court as complete a view as possible. We could do domestic easily in 14 days, but that wouldn't give the court the whole picture.
Well,
Okay.
we'll be content with that. Submissions within 28 days. If anybody can get them in earlier, that is fine. But we understand. Thank you all very much indeed. The court is now adjourned.